Jeremy Cronin. Why did I say Germany? Minister Cronin, a very good morning to you and welcome.
Good morning, Elvis. Thank you.
First and foremostly, Minister, we're asking the question to our viewers this morning, but can you explain to us the need and the reason for the expropriation bill?
Well, basically, nearly 20 years ago, the wonderful democratic constitution was passed in South Africa, bringing about a non-racial constitutional dispensation for South Africa. And in the Bill of Rights, and specifically in Clause 25, which is the property clause, it speaks about expropriation. It addresses the legacy of South Africa, in which, as we all know, apartheid and before it, decades and centuries of colonialism have resulted in an incredibly inequitable reality in which access to property, to land, and so on is hugely distorted in our reality. And so the Bill of Rights in the Constitution introduces the notion of expropriation, not just for the normal reasons that any government would have, expropriating for a public purpose like building a dam or widening a road, but also expropriation in the public interest. And it says that it defines in the Constitution public interest as being for land reform, for instance, but also to ensure the equitable access for all South Africans to the natural resources of our country. But having said that, and correctly said that, the Bill of Rights in the Constitution also then says that any expropriation cannot be arbitrary. There must be compensation, and it must follow a law of general application. And so this bill, the expropriation bill, is an attempt to provide a general law of application to guide any expropriation in South Africa.
Mm-hmm. So it is expropriation with compensation?
Absolutely. The Constitution requires that. But also what the Constitution says is that in determining the amount of compensation, a number of factors should be borne in mind. The history of the acquisition of the property, its historical use, any previous government investments in that property, the current use of the property, the purpose for which it's being expropriated, and also market value. So the market value of the property is not the preeminent or sole criteria in determining compensation, but it could be one. But certainly some form of compensation is required in all cases of expropriation.
But what happened to those or landowners that does not want their land to be expropriated?
Well, you said in the intro that this replaces the willing seller, willing buyer approach. That's, the willing seller, willing buying approach has never been the policy of government in terms of land reform, for instance. The expropriation powers exist in numbers of government departments, including the Department of Land Reform. All municipalities, all premiers in provinces have expropriating powers. But what has not been in place has been a general law of application which prescribes a process that should be followed in cases of expropriating, regardless of whether it's a municipality or a province or a national minister that is doing the expropriation.
Mm-hmm. Now, there have been accusations that the bill could lead to land grabs. What measures will the department put in place or government put in place to ensure that this doesn't happen?
Well, that's exactly what this bill is about, is ensuring that there is not arbitrary deprivation. There hasn't been, I don't think, in South Africa since 1994. But at the same time, we do need to ensure that there is a much, much more equitable access to natural resources, including land. That's a constitutional imperative. It's not just the electoral mandate of the ANC government, for instance. It's a constitutional requirement that government presses ahead to ensure more equitable access for all South Africans. But it quite correctly says that this can't be, by way of a land grab. It can't be arbitrary. The processes need to be followed. And so this bill is very meticulous in describing a administratively just process that must be followed when proceeding with an expropriation.
Will the bill address the issue of land reform in the country, which have been maybe put on a back seat due to the willing seller, willing buyer principle?
Yes, I think that this bill is not just about land reform, but certainly I believe that it will give greater confidence to those responsible in government for land reform, and indeed confidence to land owners currently and to those who are landless. And to potential investors, because where there's a vacuum on uncertainty about how land reform should be approached, I think there's uncertainty all round, and I think that this bill provides a level of certainty. But the problem with a willing seller, willing buyer approach to land reform, not least in the South African reality, is that it results in acquiring perhaps a farm over here and then another in some other place, and so it's impossible to plan a sustainable land reform process, which typically requires not just expropriation if that's needed, but also the provision of appropriate infrastructure, perhaps for small farmers and so forth. Simply buying a farm here and a farm there for land reform processes doesn't really create the conditions in which a sustainable land reform process can be advanced.
There are those that indicate, Deputy Minister, that the bill creates uncertainty, especially to property owners and international investors. What do you say to that?
Well, I say it's exactly the opposite. This bill that, as you correctly said, was passed in the National Assembly and now goes to the National Council of Provinces. This bill has been in the making since at least 2013. And as the Department of Public Works, we've been very meticulous in taking it to NEDLAC. We've consulted very extensively with business, with the unions, with the community sector. The Portfolio Committee process in Parliament took the better part of a year last year. And although different sectors and different entities, the Banking Council, Agri-SA, have all got specific issues that they want to raise, overwhelmingly they are, have been supportive of the process and have noted that this does provide certainty and security. So that there's a clear instructions, and also the judiciary, by the way, who are also often required to pronounce on the legality or otherwise of an expropriation act. In the absence of a general law of application describing the administratively just processes that should be followed in the case of an expropriation, it's also been difficult for the judiciary to make clear decisions. So I think this helps to provide certainty to investors, to communities, to landowners, and to government.
So the bill is still open for interrogation, or does it only go to the National Council of Provinces and then the President signs off? How does it work?
Well, it goes to the National Council of Provinces, and they will seek provincial mandates in the process. Literally in half an hour's time, I'm going to the Select Committee of the National Council of Provinces to present what has now emerged from the National Assembly. Clearly, the National Council of Provinces will comment on the bill, and we are confident that before the end of the year, this long-delayed, actually, expropriation bill will be enacted by the President.
Deputy Minister Cronin, thank you so much for your time and joining us here in studio.
Thank you very much. Thank you.
All right, there was the Deputy Minister of Public Works, Jeremy Cronin. Jeremy Cronin, can I get that right? Talking to us from our Cape Town studios on the expropriation bill. And there's, of course, a question that we pose to you. That question is on your screen right now.